So, I think we'll start with an update on where Ripple is with its lawsuit with the SEC, that little known lawsuit. So for anyone who hasn't been following the case, the SEC sued Ripple in 2020 for allegedly raising money by selling its XRP token, which the agency said should have been registered as a security. You recently won access to some documents you were seeking. Both sides have also asked for summary judgment. So maybe give us kind of an update.
State of the state.
The state of the state. Where do things stand, and what's the significance of where we're at?
Well, it's great to be here. It has certainly been a busy couple of years. As you said, the SEC first filed a lawsuit against Ripple and actually myself and Chris Larson in December of 2020. So it's been almost 2 years. And, look, I think at the beginning of this, we actually made the public statement that, this isn't just about Ripple. This is really about the whole industry. And I think at the time, in December 2020, people were like, no, it's not about the whole industry. Today, I think everyone acknowledges how important this is for the U.S. and the U.S. leadership around crypto. This is obviously, I think everyone would agree now, a pretty bellwether case. Where the case stands now is both sides, the SEC and Ripple, have filed motions for summary judgment, which basically means, hey, we don't think we need a trial. This isn't a question about the facts, it's a question about the law. We think the law is very clear, and the judge, those will be fully briefed in front of the judge by mid-November, and then the judge will take as much time as the judge wants to take to make that decision. One thing you commented on that I think is worth spending 1 second on, the judge, so there's some notes associated with for the crypto industry, a very well-known speech that Bill Hinman gave in June of 2018. And in this speech, he said that ETH had, I'm paraphrasing, but ETH perhaps had been a security, but it transitioned to not be a security because of its decentralization. And, that's not actually what the law says. What the law says, there's no mention in the Howey test about decentralization, but that speech was really, really important. And the judge now, over the last 18 months, has ordered the SEC to turn over the notes associated with that speech 6 times. So the recent discovery ruling that went our way is just the 6th time. And the only reason I mention that is because, the SEC obviously celebrates disclosure. It celebrates transparency. Why can't we do the work as the SEC and as a federal government to actually define and provide clear rules of the road? And if we had those, I think everyone would actually, the industry in the U.S. could thrive, much more easily than what we're dealing with now.
So in kind of the order that you were talking about, are you expecting that to help even in the case of summary judgment, or is this more of something that you're looking to help in the slim chance that the judge denies those motions and this goes to trial?
Well, I think the question we're asking is, what are they trying to hide? What is it in these notes that they have been ordered 6 different times to turn them over to us and we still don't have them? Each time they've, filed appeals or, new derivations of attorney-client privilege. And, so for me, as much as anything, it's what is in these notes that they are so committed to not sharing with the world? And look, I think most people who look at this situation, I have no idea. I can't wait. I hope we get to see them. We'll find out, I hope. But, if you step back and just think about this from the big picture, at the time, XRP, and people forget this, but at the beginning of 2018, before that speech, XRP was the 2nd most valuable digital asset after Bitcoin. And then the SEC kind of anointed ETH, and ETH obviously has benefited from that. And then not too much longer, another year and a half later, the SEC filed a lawsuit against Ripple asserting that XRP is a security. And the nuances and the distinctions between, is something adequately decentralized to make it not a security, which again isn't what the law says. And again, I'll digress and maybe pontificate for 1 second. I think we all have to remember the SEC only has the power that Congress gives it by statute. Right? They don't just get to go and take power. Congress gives them that power. And in this case, it's the 1933 Securities Act that says, here you have to have an investment contract. And then eventually there was something called the Howey test, which we can talk about if it's, in the weeds, but interesting maybe.
We want to get into the intricacies of the Howey
Georgetown
test.
law professors will find it very interesting, and yeah.
That's true. So are you getting any indication of when, this lawsuit will be concluded, when you'll get some sort of resolution?
So I do think it'll be fully briefed in front of the judge by mid-November. Federal judges work at their own pace. And I think it's very hard to predict. Maybe optimistically, you're talking about a few 3 to 4 months. Pessimistically, you're talking longer than that. I generally have tried to guide when people ask internally at Ripple. I kind of say, look, I think we'll have an answer the first half of next year. Whether that's the first quarter or second quarter, we shall see.
And at this point, would Ripple consider a settlement with the SEC?
It's a good question. I mean, as long as the settlement includes clarity that XRP is not a security, yes, absolutely.
Do you feel like the SEC is?
Well, I mean, in my opinion, the SEC's kind of painted themselves into a corner because they are resolute. They're taking the position, and Gary Gensler has gone out and said that the crypto industry is the Wild West, and virtually all tokens he thinks are securities. So any settlement, why would we settle if you're not saying that XRP is not a security? It's so clear to me in terms of how, and even the amici briefs that have been filed on our behalf in the court, people who have nothing to do with Ripple, who never heard of Ripple, they're participating in the XRP ecosystem as an open source, decentralized software. And so I just think that the settlement opportunity has to start with the idea that XRP is not a security. Beyond that, I think everything's on the table.
Got it.
But if Gary Gensler's of the mind and the SEC seems to be of the mind that, hey, the vast majority of tokens are securities, that creates a conundrum for how to settle anything.
If, let's talk about the hypotheticals here. So if Ripple loses the case, what's kind of the next step for the company, and maybe what do you think would be next for the industry as a whole? Yeah. And then I guess opposite, if you win, what's kind of the effect of that you're anticipating?
Well, so something that's actually, I think, been kind of misquoted. I've commented on this publicly once or twice, and it's been misquoted. The thing to understand is today, when the SEC sued Ripple, basically every exchange in the United States either halted trading of XRP or delisted XRP. So for all intents and purposes, XRP does not have liquidity in the United States. Ripple as a company, we have grown gangbusters over the last 2 years, but we've signed hundreds of new contracts with financial institutions globally, and very, very few here in the United States, because in the United States most financial institutions will say, hey, let's wait and see what happens here. So when people ask me what happens if we lose, I'm already operating as if I lost, right? The XRP doesn't trade in the United States. It can't get worse, right? So I mean, look, it is kind of funny. It's also what the problem is with having a regulator who, in this case, they're kind of being a bully, and they're kind of the reason why they're able to get a lot of settlements is because people don't have the financial resources, the commitment to really fight it. And would we be in a better position now had we tried, been more flexible in settling way back when? Maybe, but the whole industry would be in a worse place. Gotcha.
So let's talk about, I think kind of in the absence of specific regulation, I know the SEC has said that they think the rules are clear and you just have to follow them. You mentioned the Howey test, which I believe was citrus orchards to start with.
Yep.
But in the absence of specific rules, people have been looking to the enforcement cases, what's happening in the courts, statements from Chair Gensler. And he recently talked about the transition of the Ethereum blockchain to proof of stake, which is basically you get rewards if you put some of your assets up to help validate transactions. At least that's my understanding. You've had some choice words about that. How should the industry take those comments, and what are your specific thoughts on that?
Well, when you first started to say, Gary Gensler's had some recent comments, I thought you were going to talk about Kim Kardashian. I do think this is an important, relevant thing. So, again, the SEC would portray to all of us, I think, hey, the rules are clear, but then they won't publicly state, is ETH a security? Gary Gensler's been asked point blank, is ETH a security? If the rules are clear, answer the question. It shouldn't be that easy. If the rules are clear, so what you're saying is, the code, the technology underlying ETH is the determinant as to whether or not something is a security? Wait, and you're telling me the rules are clear? Like, that doesn't make any sense. Let's not look at what the code is doing. Let's understand, I mean, because whether it's a proof of stake or proof of work or consensus, I don't understand. I mean, certainly the Howey test says nothing about that, right? So this is now getting into, I think, the SEC taking power as opposed to doing the work, right? Like, there's a rulemaking process where you do rulemaking, you have public comment, you go back and forth, and you do the hard work to create clear rules, potentially even new legislation. That's not what we're doing in the United States. What we're doing is we're hiring more enforcement lawyers. We're going after, in my opinion, kind of edge cases. And, you know, because we went after Kim Kardashian and got a settlement, does that mean ETH Max is a security? I mean, I guess it is. It does mean that because the SEC did the settlement with Kim Kardashian. You know, it's the same problem with the former Coinbase employee. That, okay, they're going after a Coinbase employee, but if those were securities, why aren't they going after Coinbase? And so, like, if the rules are clear and the SEC is trying to provide clarity, like, it's mad. I'm pretty familiar with this stuff, and I can't figure it out. So I think that we should all expect, and frankly, we should call upon our elected officials to put pressure on the SEC. Let's make clear rules. The vast majority of people in this room, certainly, and that we all work in crypto, we want to follow the rules of the road, but you got to be clear about what the rules of the road are. And as you pointed out, a Supreme Court case about a citrus grove in Florida from, I think it was 1938. I'm not sure the year, sorry. 1948?
1946.
Yeah, anyway, somebody I'm sure here. Yeah, it was a while ago. Trying to apply that here is tricky. And so let's do the work. Good news is there is legislation that has some momentum. I think Chair Benham this morning from the CFTC had some very, I think, sage thoughts on this point, and I think that the trend line looks positive.
Well, I guess speaking of the CFTC, I know that they recently had an enforcement action that Chair Benham spoke to, the Oct.11 action that also held governance token holders liable as well for the violations. I'm curious. I know some in the industry have been pretty upset about that action, having felt like the CFTC has been kind of an ally for them. I mean, what are your thoughts?
Well, I don't want to confuse being an ally with going after fraud. And like, I don't know the specifics of this particular case. I haven't followed it closely. I think there's no question there have been bad actors doing things they shouldn't do, and whether it's the CFTC or other parts, the Department of Justice going after scams and frauds, I think we all should support that and encourage that. What I heard, Chair, I was in the back when Chair Benham was speaking, and what I heard him say is, roughly, if DAOs think they can operate outside of regulatory frameworks, they're going to be sadly mistaken. On one hand, that was a powerful, important statement. On the other hand, I hope that's not a surprise.
Well, and speaking to the enforcement side of things, I think what constantly comes up from the industry side is this idea of regulation by enforcement. But I want to note too this, the president put out a release on all of the reports we've seen out of the March executive order, which called for a coordinated approach to digital assets. And in that release, it did kind of sanction sort of the SEC and CFTC. What it said was it wanted them to aggressively pursue investigations and enforcement actions in this space. I mean, what do you make of that?
Well, I think the one interesting thing, my recollection of the executive order was the SEC was never named individually. It was the SEC and CFTC. And so right now the SEC is operating as if they are in charge. And they're gonna protect us from, I'm not sure what, Kim Kardashian. I do think, I go back to the executive order, I think is well-intentioned and brings attention to the need for clarity. I think all of us would benefit by continuing to push in whatever way we have available, whether that's through the court process, as Ripple is doing, whether that's through the legislative effort, the Digital Commodity Exchange Act in the House Ag Committee, Ripple has been a big supporter of. I think it provides some of that clarity. I'm not up here trying to pretend that enforcement actions shouldn't be brought. There absolutely have been bad actors. There's no question. I'm not sure that, the irony of the Ripple case in terms of the reality is you have, I think now 75,000 XRP holders who want to sue the SEC. Now keep in mind the SEC's mission, one of their statements is to protect the investor community, to protect effectively consumers. So wait, how did they protect that community by filing a lawsuit and driving $15 billion of value out of that ecosystem?
Well, I want to kind of switch gears here a little bit. This part of this discussion is about enterprise crypto as well, and Ripple has a lot of institutional clients. Can you talk about, has the sort of lack of regulation in the U.S., has that affected your clients or your interactions with them, or maybe elaborate?
The reality, so Ripple definitely, since this lawsuit started, the last 2 years, we have grown gangbusters. We've signed, I think I've publicly said, hundreds of customers outside the United States.
Yeah.
So it has affected our business domestically, and the U.S. is still the largest economy in the world, and so I clearly care about that. But I also, the problem we're solving is a global, one of the primary things we focus on is cross-border transactions, payments. And so, most people outside the United States don't really care that the SEC is suing us. I'll tell you a very quick, funny story. I'll keep it short. I was in the Middle East last fall, and we were meeting with customers. I have one of the Ripple team members who's based there. It's really early in the morning. My time zones are all screwed up. We're meeting with the CEO of a payments company, and but the employee from Team Ripple says, "Well, why don't you give an update on what's going on at Ripple?" And I start talking about the SEC. And after the meeting, he very delicately says to me, "No one gives a shit." And his point was, if you're not in the United States, the governments in Abu Dhabi, governments in Switzerland, Singapore, UK, Japan, they provided the clarity how they view and categorize digital assets, and they don't care that the United States SEC has a viewpoint that is, pending in court.
Well, and I mean, you talked about there have been some efforts, at least in the U.S., to try to pass new legislation, though with the end of the year kind of fast approaching in the midterm elections, we'll see how that pans out. But I mean, how much do you think those efforts would move the needle? You talked about the bill to give the CFTC more jurisdiction. We also have a stablecoin draft in the works.
So I think the most important thing in those bills is what are the definitions? Is there definitional clarity? And sometimes I think there's work to be done on some of those points. One of the reasons why we have focused on the Digital Commodity Exchange Act in the House Ag Committee is because we feel like it is clearer. The less clarity, the more we as an industry are going to end up back in enforcement, regulation through enforcement.
What's your sense of something happening this year? And if this gets pushed to next year, where do your confidence levels go?
I am certain there are people in this room far smarter than me to answer that question. I agree with your point. We have midterm elections. What's going to happen? I don't know. There is some momentum, which is great. And I think there'll probably be some hearings, which brings attention and builds momentum. I think, smart money seems to be the over-under on something passing is, well into 2023. Maybe that changes, but we'll see.
And how do you see the crypto landscape evolving? You mentioned that a lot of your business right now is overseas. We have seen some action, MiCA, kind of the new framework over in the EU. And just curious, how is the fact that they're maybe a little bit closer on sort of a broad package, how does that affect the industry as a whole?
Well, I think it affects the industry as a whole, and I have said on stages like this before, if you're an entrepreneur thinking about starting a company in the crypto space, you should go where you have clear rules. And if that means you're going to London because there's clarity in London, then great, go to London. But starting a crypto or blockchain company in the United States where we can't get clarity on what defines a commodity token, a securities token. If these things aren't clear, if I were you, I wouldn't do that here. As a further example, Ripple will add about 300 employees this year, and our goal has been to make sure that over half of those are not in the United States. So our London office has grown a lot, our Singaporean office has grown a lot. And look, I would rather be hiring people here in the United States and continue to grow our business domestically. But if we can't, because of this lack of clarity, it doesn't really make a lot of sense. One just last quick point on this. It's interesting to me, for those in the room who've been around a while, as I have, in the late 90s, Congress passed laws that made clarity around the internet, as we know it, the internet today. There was clarity around how it would be regulated. And inflows, capital, and entrepreneurs starting all kinds of companies in the internet space. And to this day, the United States has been the beneficiary on a geopolitical basis of the fact that the internet is kind of centered in the United States. I believe that blockchain and crypto will have the same kind of multi-decade effect. And if the US doesn't get this clarity, it will thrive. It'll just thrive outside the United States.
Got it. Are you optimistic about when or if we ever get some sort of kind of broad package? I know we have a proposal from Senators Lummis and Gillibrand that's been out there for a while now.
As I said earlier, I'm not a Washingtonian insider. I don't feel conversant on predicting likelihood of success on some of these things. As I said, I'm a believer that what is pending in the House side and the digital commodity DCEA is something that I'm a big believer in and feel like it would provide a lot of clarity relative to where we are now. It would go a long ways.
Gotcha. Well, we're about almost out of time. I guess any final words of how you think the next couple of months are going to go for Ripple, for the industry?
I guess my final word will be, I think we all should be super appreciative of Chris and the team here for throwing an event like this. I'm serious. Like, having DC focus on this is important. So I think having an organization like what Chris has done here, bringing a group together, bringing a group of leaders to elevate the voice. Maybe the very, very last thing, which, if you've seen me speak publicly before, I will say, the biggest thing holding crypto back is the tribalism in this industry. We are all on the same team. We don't have to kill each other to succeed. And I just don't understand why there's so much infighting so often. And I do think events like this help raise everybody, and that's a very positive thing. That's it.